including. Thank you very much for participating in today's webinar. My name is Eckhard Wallenmacher. I'm with the German-American Chamber in Atlanta. We're very happy to be here today in Washington as the representative of German industry and trade. Caitlin Hickey, who works with the RGIT, and Jim Kearney, who works or is a lawyer with Womble Bond Dickinson. I still have to learn that since you changed your names recently. Our specialists in the fields of Iran sanctions have extensive experience with sanction policies and will walk us through today. We'll start with Caitlin. She will give some remarks and some information about what RGIT stands for and what they do. For housekeeping purposes, we are allowing chats on the side. We have muted everyone so we can concentrate on our two speakers. If you have any questions throughout the webinar, please use the chat functionality and I will answer as we go. After Jim has finished his presentation, we'll open it up for question and answers, and we will do that in chat form as well, just because there's way too many participants today in this webinar to do it via voice ask, question ask. Thank you. So, Caitlin, please.
All right, thank you so much. Glad everyone participating in the webinar can see a little bit of our office. You might be able to see the White House in the corner just a little bit. So it might be a good opportunity just to kind of explain what the representative of German Industry and Trade, RGIT, actually is and what we do here. So we have two principles in Berlin. The first is the Federation of German Industries, the BDI. They are the umbrella organization for the industry associations, the different sectoral associations. So things like the automotive, or let's say the chemical association, the aluminum association. And then on the other side, our second principle is the DIHK, which is the Association of German Chambers of Commerce and Industry. So they are the umbrella organization as well for the German Chambers of Commerce within Germany, as well as the network abroad. Here in the United States, as you all are probably familiar with, there's the German-American Chamber System, covering all the different regions of the United States, with each of the regional headquarters being New York, Atlanta, Chicago, and newly in San Francisco. So what we do here in RGIT, we're not a typical chamber, as you may be familiar with. First of all, we have the two principles, but also we don't do typical chamber services. Instead, we're more of a political office representing the interests of the German business community, BDI and DIHK, here before Congress, before the different administrative agencies. So we're talking about something like sanctions, which is an area of concern back in Berlin, mainly on the Russia side, the Iran side. We are often dealing with the House and Senate Foreign Relations Committees or Foreign Affairs. In Treasury, that would be the Office of Foreign Assets Control, OFAC, and as well the State Department plays a hand in some of the sanctions policy. So often what we do here at RGIT, we do one-on-one meetings. Of course, we bring in delegation trips for industry associations or companies who are wanting to make their case one-on-one before state or OFAC. We submit position papers, just anything we can do to kind of communicate the interests of the German business community here in Washington. And we're here full time. We're celebrating our 30-year anniversary. So we have a full representation here. So now I'm gonna maybe give just a little bit of an overview of why this decision regarding the Iran deal by President Trump is so important for German business. Why are we talking about Iran, when we are German business? So first, kind of looking a little bit at the overall trade relations between Germany and Iran. They've been steadily improving since the implementation of the Iran deal. Every year, the trade statistics have been increasing. the most recent numbers we have from 2017 show that the trade relationship is at roughly $3.5 billion. And as I said, it's continuing to rise. So forecasts even for 2018, maybe not taking into account what happened with President Trump's decision, we're also anticipating further increases. In Germany itself, approximately 20,000 jobs depend on trade with Iran. So within Germany, it's an issue of people are actually thinking about their actual job and being employed. Some of the goods that Germany is exporting to Iran are in the areas such as machinery and industrial equipment, motor vehicles and commercial vehicles, electrotechnical and pharmaceutical products. And on the Iranian side, they're exporting things like fruits, nuts, and mineral fuels. Now, since the announcement by President Trump to withdraw the United States from the Iran deal, the number one concern we're hearing is uncertainty. And for businesses who are planning not just short term, but medium and long term, uncertainty is bad for business. Doesn't matter what the topic is, could be sanctions, could be other trade issues, but uncertainty in general is bad. And some of the things we've been hearing on the political side is don't expect any exemptions to be made for German or European companies. The first warning shot came from the U.S. ambassador to Germany, Richard Grenell. The day of the decision by President Trump, he immediately tweeted out that German companies should wind down their business, which is a fairly strong statement for an ambassador to make. On a more formal side of things, back at the beginning of June, European ministers, including from the German side, sent a letter to their counterparts at Treasury and State, so Mike Pompeo and Stephen Mnuchin, and they formally requested exemptions, broad-based exemptions for European businesses who are engaged doing business in Iran. We've heard within the last week or so that this request was officially rejected by Treasury and State, and they are instead conveying the information that businesses, that basically the only exemptions are going to be made for humanitarian or national security reasons. So if you are looking at the deadlines that are coming up in August or November, everything that we're hearing from the administration is pointing to don't bank on getting any sort of exemption. They are going to want to impose sanctions in the strongest manner possible. Yet at the same time, undoing business in Iran is complicated, and that's been one of the main concerns from our principals back in Berlin. You have things like legal contracts that have been signed. Maybe those are difficult or maybe even impossible to unravel. Some of these things might take time. We're not hearing any signals from the administration that they will be welcome to maybe grandfathering in anything. They're looking at hard deadlines, stop doing business on the dates that they set forth in August and November. Ultimately, what we're seeing at the end of the day is a lot of German businesses, but not just German, other European businesses as well, are making the decision to withdraw from Iran. There's too much uncertainty about financing. There's too much uncertainty about how U.S. sanctions will be applied. And at the end of the day, the U.S. market is simply just much more attractive than the Iranian market. I mentioned the trade statistics earlier between Germany and Iran at just about 3.5 billion. Well, if you compare that to the same period, 2017, the U.S. and Germany, that relationship is 171 billion. So, if you want to do business in the U.S., you might want to comply with the U.S. sanctions more than testing the waters in Iran. So with that being said, I think I'll turn it over.
Thank you, Caitlin. Give me a second to change the share of the presentation so you can see the presentation from Jim Kearney. All right, we're ready.
thank you very much, and it's a pleasure to be here. Let me drill down a little bit on the really fine overview that we just heard about the importance of the Iran sanctions, the U.S. withdrawal from the JCPOA, and the basic snapback of the pre-JCPOA sanctions. On May 8th, the U.S. announced its intention to withdraw from the Joint Comprehensive Plan. It initiated its plans on that date to reimpose the U.S. nuclear-related sanctions that had been suspended under the terms of the 2015 nuclear agreement. Although there had been some hope that perhaps the snapback of sanctions would be restricted to a few key sectors such as petroleum or aircraft, it was basically a comprehensive snapback to the pre-JCPOA sanctions. At the same time, the Treasury Department announced its establishment of wind-down periods for activities involving the Iran sanctions. Flipping the slide to the next slide, these wind-down periods are interesting. They're organized around two separate periods, a 90-day period and a 180-day period. We're coming upon the August 6th deadline for the first wind-down period. By the end of that 90-day period, August 6th, any transactions in a variety of areas will no longer be permitted, and any pre-existing activities will need to cease to exist. And that would include transactions involving the purchase of US dollar banknotes by the Iran government, trade in certain precious metals such as gold, trade in various minerals like graphite, semi-finished metals, coal, software for industrial integration use, transactions in the Iranian rial, trade in Iran's sovereign debt, and any transactions relating to the Iran automotive sector, all of which must wind down by August 6th. The 180-day period ending on November 4 will address port operations, transactions relating to shipping and shipbuilding, all petroleum-related transactions, transactions with the Central Bank of Iran and other designated financial institutions, and specialized financial messaging services that had been provided to the Bank of Iran and other institutions in Iran. Any underwriting services, insurance services, reinsurance services, and transactions relating to the energy sector. All of those activities are subject to the deadline of November 4, ending the second wind-down period. Next slide. So what does this mean? The implications for U.S. persons, less impactful, frankly, than the implications for non-U.S. persons. Even after the JCPOA, the U.S. persons were still broadly prohibited from transactions with Iranian entities. Certain primary sanctions had been lifted, permitting import of items such as Iranian carpet, foodstuffs, case-by-case exportation of commercial aircraft and related goods and services now became permitted post-JCPOA. I should point out, when I use the term U.S. person, it has specific meaning under U.S. sanctions laws. A U.S. person is a U.S. citizen, a U.S. entity incorporated under a law of the United States, or a permanent resident alien of the United States. And for purposes of corporate entities, a U.S. person is also the foreign branch of the U.S. incorporated entity. So all those persons now were snapped back to the pre-JCPOA sanctions status. At the same time, and in implementing the May 8 directive, OFAC announced that the JCPOA authorizations that related to the import of Iranian products, foodstuffs, and carpet, and the export of commercial aircraft were subject to the 90-day wind down. OFAC at the same time revoked General License H, which had permitted foreign subsidiaries of U.S. companies to engage in certain business activities. That will be revoked in its entirety, and all such activities must cease after the 180-day wind down period. Another general license, License I, which had permitted contingent contracts, contracts anticipating a later transaction with Iran, would also be revoked. And equally importantly, OFAC revoked its previously issued statement of general policy, which had indicated a favorable orientation by the U.S. government for the licensing of passenger aircraft sales. That statement has now been revoked. Next slide. As I said, the implications for non-U.S. persons, and as Caitlin has indicated, are fairly impactful. Non-U.S. persons, any person, entity, not a U.S. person or entity, including non-U.S. subsidiaries of U.S. persons. They are considered for purposes of snapback sanctions to be non-U.S. persons, are subject to secondary sanctions if they're engaging in any activity that had been undertaken pursuant to the JCPOA authorizations, and are subject to wind down by either the August 6th or November 4th deadlines. Possible sanctions that could be imposed, secondary sanctions that could be imposed on non-U.S. persons for violations of the U.S. sanctions include restricting access of those entities to the U.S. financial system and to capital markets in the U.S., blocking of property and interest in property in the U.S. or under the control of a U.S. person, prohibition from importing goods, technology, or services into the U.S. OFAC did clarify, and has clarified through a couple of statements in the ensuing weeks, certain important issues for purposes of non-U.S. persons' interest in the reimposition of the sanctions. It will still be permissible for payments to be made, for non-U.S. persons to be made whole for any debts or obligations owed to them by an Iranian entity or person for goods, services that the non-U.S. person fully and completely provided before the end of the wind down period. Similarly, any loan transactions, any credit extended, payments owed under those pre-existing transactions will be also permitted before the end of the wind down period. Focusing a bit more specifically on this, for supplier transactions, the services that are the supplier transactions must exist pursuant to a written contract agreement. That contract agreement must have been entered into before May 8. The goods and services must be fully provided to the Iranian entity prior to the end of the wind down period, but payments may be received after the end of the wind down period. However, no new supplies may be provided or services provided under these pre-May 8th contracts after the end of the wind down period. Parallel conditions exist for repayments of loans, credits. The loan credit transaction must be documented by a written contract agreement entered into before May 8. The loans credits must have been extended fully prior to the end of the wind down period that applies to them. But payments against those loans and credits may be received after the wind down period. But again, no additional loans, no additional credits may be extended under the pre-May 8 contracts after the end of the wind down. So we have heard in Caitlin's summary some of the reaction to the U.S. withdrawal and the reimposition of the sanctions. Post-May 8, the EU and UK indicated their commitment to remain in JCPOA. The EU has reinvigorated existing blocking statutes that had last been used, I believe, in the 1990s, latest date. They were used then to limit the extraterritorial effect of U.S. sanctions against Iran, Cuba, and in that era, Libya as well. There's really little track record to go by with respect to how effective the blocking statutes were then or could be now. They prohibit compliance with U.S. sanctions measures, including any administrative orders by U.S. authorities, any court judgments by U.S. courts, and they establish a protocol that would permit an EU entity to seek damages in an EU court if it is injured by dint of the imposition or enforcement of the sanctions. But I believe that the penalty and the penalties that would weigh against an EU entity not cooperating with the blocking statute would be basically left to the decision of member states. In addition to reinvigorating the blocking statutes, the EU threatened to file a WTO complaint, and as well, as Caitlin indicated, initiated a variety of lobbying actions to attempt to persuade the U.S. to either exempt certain EU companies, perhaps because they had pre-existing contracts with Iran that pre-existed the JCPOA, or basically to exempt particular sectors that were of importance to the EU. I think, as Caitlin indicated, the status of those lobbying efforts are very much unclear right now, particularly in view of the recent political rhetoric that has been ongoing. I think there is probably little likelihood that you will see immediately, at least, any agreements with respect to relief from these sanctions. But that brings us to the gist of the next slide. This is really a developing story. There is very little legal certainty for companies other than the certainty of the requirements, obligations, and prohibitions of the sanctions as they have been implemented by the U.S. Office of Foreign Asset Controls. OFAC and other relevant agencies, which include the U.S. Department of State, are expected to issue additional regulations and guidance, and certainly post August 6th, the end of the first wind down period, will be establishing some priorities of their own with respect to enforcing the sanctions against non-compliant companies. The prioritization of enforcement activities is a critical decision process, because it will not be the case that immediately after August 6th, every company that is not compliant at that point will immediately face an enforcement action. Enforcement proceedings, like prosecutorial discretion, are exercised pursuant to the discretion of the enforcement agency, aligned with whatever priorities exist and whatever goals are set for purposes of the sanctions program. What we do know is that even post May 8th, there has been increased activity to designate as specially designated nationals who are subject to individual sanctions by the U.S. government, increase in the activity of imposing sanctions on key Iranian nationals. The political discussions are ongoing, and these will continue to be ongoing, I suspect, even as we enter the post-wind down periods. My suggestion, among others that we might talk about in the Q&A period, is to monitor the OFAC website, which is very timely in terms of very quick to post any developments that may occur, either in the terms of the issuance of new general licenses that might favor a particular sector or country. And beyond just checking the website, I highly recommend subscribing to OFAC's email notification service, which is a daily listserv distribution of the latest actions by OFAC with respect to all the sanctions programs. It comes directly into your email bank, and I've included the website drop-down link that takes you to the page where you can subscribe. And with that, I'm happy to field any questions.
Thank you, Jim. Thank you, Caitlin. We're opening up. Please ask your questions via the chat.
Hello, my name is Oliver. I'm within a pharmacy company in the in Germany. We are dealing with the Iranian market as well. And my question is also up right now. We are just in the time that we want to found a new subsidiary in the US market. And whether I don't know if it makes, if there will be any sanctions for our headquarter in Germany, if this one is dealing with the Iranian market.
Well, that's a very good question, and it depends on a lot of circumstances. When a pharmaceutical company that may be providing medications, other items like that into the Iranian market, may be doing business in a sector that will not be of the highest priority for the U.S. government. Currently, under all of the comprehensive country sanction programs that the U.S. maintains, there are general licenses or policies favoring specific licenses for certain agricultural and medical items that are viewed in the nature of, if not direct humanitarian aid, assisting individuals and not the respective governments. So it could be that that type of business, that type of sector, will not be of a high enforcement priority, or may in the end be the beneficiary of a general license, and may be something to pursue specifically with OFAC. Again, the enforcement agencies have got, as all government agencies, limited budgets. Their enforcement activities are targeted around impactful activities that will meet the policy goals that are set in place. It is true, though, that the sanctions as they're written, whether or not in terms of the parent company, could be subject to the secondary sanctions, regardless of whether they have a U.S. subsidiary. The U.S. subsidiary, as a U.S. person, would be subject to primary sanctions for violations of those sanctions. So it is theoretically possible that that's a risk for you.
Okay, understand that. Okay, thanks for your explanations in that.
All right. Do we have any more questions? Here's a question coming through. Do you foresee issues in the retail sector?
Again, I'll hark back to some of the statements previously made. Retail sector is kind of a broad notion. Retailing what? Retailing automobiles, automotive parts, maybe one thing. Retailing pharmaceuticals may be another thing. So clothing items, for example, I would not suspect are among the high priority sectors. On the other hand, you know, especially clothing retailers or whatever may find themselves in an area a sector that's in more of the interest of the government. So again, it's not among any of the listed sectors that have been specifically identified in the sanctions to date, but it's an activity involving Iran. So for a U.S. person, it is prohibited. With respect to the secondary sanctions on a non-U.S. person, it may or may not be.
She specified he specified the question into if brick and mortar stores are affected in the sense of Iranian nationals shopping in those stores, whether luxury goods, for example, whether those shops are in the US or in China or in the EU. Now, I would think Iranians are currently on the list of countries that you cannot come into the US for. So, so would shopping in a store constitute a problem for the shop owner?
Shopping in a store where? In the United States?
Yes.
And if the store in the United States is an Iranian-owned store?
No, items bought by Iranians.
Iranians coming to the United States to shop. There's no prohibition on Iranians coming to the United States. We permit visas for Iranians. They obviously have to obtain those visas outside of Iran. And there are restrictions in terms of banks facilitating the travel, U.S. banks, but there's no prohibition on Iranians coming to the U.S., and you see that quite frequently.
Okay. All right. I hope that answered that question. Do we have any other questions? Yeah, your connection is difficult to hear. Maybe you should send it through as a chat question.
Okay, will do.
Thank you. Was there anybody else in the line that wanted to ask a question?
Yeah, Jim, I had a question, possibly two questions really. One would be, if you could sort of expand a little more on the corporate definition of U.S. person. If you have a company that has multinational operations, perhaps a non-U.S. Parent company with U.S. subsidiaries and other foreign subsidiaries, what is sort of the best practice as far as figuring out, or sort of all of the foreign affiliates, if it's a Chinese company or South American company, are all of those, by the fact that they're affiliated under common ownership with the U.S. With U.S. companies, therefore deemed to be U.S. persons?
No. Foreign parent of a U.S. incorporated entity is not a U.S. person by dint of its ownership of the U.S. entity. The U.S. entity is a U.S. person. And if the U.S. entity has a branch office abroad, that branch office is considered part of the U.S. person. But no, the affiliation is not established under those circumstances.
Okay. And then I guess a second question on that is if you have companies that have also entered into sales relationships with third parties, whether they be distributors or other resellers of your products, is there any concern or risk for the U.S. company to have liability if that distributor or that reseller then goes on to violate sanctions and sell into Iran for goods that are covered?
Yes, potentially there is risk. If the U.S. person knows that the business plan includes marketing and sales in Iran, then it is culpable for the actions of that distributor or reseller. If you're selling to a reseller on account, you're selling 10,000 widgets and you have no idea that goes into the inventory of a distributor or a reseller, and you have no idea where it goes from there, you've got a defense for any accusations that the reseller sold into Iran.
Okay, thank you very much. That was very helpful.
Any more questions? The person that tried to speak on the phone but we couldn't hear, maybe give it a try again on the phone.
Hi, is this a little better?
Oh yeah, perfect.
Hey, this is Sylvia Judy. We had in 2013, 2014, a PET medical scanner that went to the hospital in Tehran, King's Hospital in Tehran. And, under proper OFAC licenses. Now, this is radio pharmacy, which still requires certain components to be shipped from the U.S., and the manufacturer is a U.S. entity. Will that affect the supply of radio pharmacy articles, supplies in future after November 4th?
There has been no indication that any of the AgMed permitted transactions previously permitted and authorized, like the one that you had the benefit of, have been revoked by these sanctions. Whether or not this other U.S. supplier can take advantage of your pre-existing license depends on exactly what the license says. But I would recommend that an opinion, an advisory opinion ruling, perhaps should be obtained from OFAC regarding that set of circumstances, regarding the continuing applicability of the AgMed agricultural and medical product license, and the ability of the U.S. supplier you talked about to as well take advantage of that.
Right. Thank you so much.
Any other questions? Feel free to ask. Okay, I'm not receiving any other questions through the chat either. So we'll conclude this webinar. If there's any questions afterwards, please feel free to email. We'll be sending around a video up, or we'll send around the link to the video once we're posting it on YouTube. And I want to thank Caitlin from RGIT, as well as Jim Kearney from Womble Dickinson, for taking the time today. I hope you found that interesting. I know it's not on top of mind for everyone, but I think it's a very important topic to keep in mind as it affects German-American businesses. And I hope it will turn out to be in a positive conclusion as we all hope it will. Thank you. Enjoy the rest of the day.